Is birthright citizenship a thing of the past? The ongoing debate about birthright citizenship in the United States has raised significant constitutional questions, particularly following President Trump's executive order. A closer examination of the Constitution, historical precedent, and the role of executive orders demonstrates why such an action won't be legally indefensible. The clearest legal foundation for birthright citizenship lies in the 14th Amendment to the Constitution, which was ratified in 1868. Its Citizenship Clause states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This language explicitly establishes the principle of jus soli, or citizenship by birth on U.S. soil, and makes it a constitutional guarantee. Now, critics often argue that the phrase subject to the jurisdiction thereof excludes the children of undocumented immigrants. However, legal and historical interpretations refute this claim. In the United States versus Wong Kim Ark back in 1898, the Supreme Court upheld that the 14th Amendment grants citizenship to virtually all children born on U.S. soil, regardless of their parents' immigration status, as long as the parents are not foreign diplomats or enemy occupiers. Now, an executive order is a directive issued by the president to manage the operations of the federal government. While such orders have broad administrative utility, they cannot override constitutional provisions or interpret Supreme Court precedent. Plainly put, the Constitution supersedes executive orders. Article 2 of the Constitution grants the president the power to ensure that the laws are faithfully executed. This does not include the power to unilaterally rewrite the Constitution or reinterpret its provisions. Executive orders are subject to judicial review and can be struck down if they exceed the president's authority, as seen in cases like Youngstown Sheet and Tube Company versus Sawyer back in 1952, where the Supreme Court invalidated President Truman's attempt to seize steel mills during the Korean War. Moreover, the Constitution's separation of powers ensures that changes to its provision require an amendment process outlined in Article 5, involving both Congress and states. An executive order bypassing this process would violate the balance of powers. The Supreme Court has consistently interpreted the 14th Amendment broadly. Wong Kim Ark remains the definitive case on this matter, and overturning this precedent would require a new Supreme Court ruling or a constitutional amendment, not a presidential directive. The United States is among several countries that recognizes birthright citizenship. It aligns with principles of equality and inclusion, distinguishing it as a nation of immigrants, and a unilateral attempt to end birthright citizenship via executive order would likely trigger widespread legal challenges and social unrest. It could also undermine public trust in constitutional governance, eroding the principles of democracy. To sum up, birthright citizenship is a constitutional right enshrined in the 14th Amendment, affirmed by the Supreme Court, and deeply rooted in the American ethos. It cannot be undone by executive fiat without violating the Constitution's plain text, Supreme Court precedent, and the separation of powers. Any effort to change this principle must follow the formal amendment process requiring a broad national consensus. What are your thoughts? Drop me a line in the comments section. Don't forget to like, follow, and subscribe and share.